Welcome back to COM 330. We are looking at 4 privacy torts, continuing on from the last video. This is video number 2 in privacy. We're continuing on from the last video where we looked over some other things. Now we are going into privacy torts. And the first one we are looking at is publishing facts or embarrassing private facts is what we're looking at. And there are 4 considerations I mentioned at the end of the last video, and we're going to look at the first of those, which is publication. It has to be published, and in particular, did it reach many people? How many people did it reach? The number of people it reaches, or the fact that it is reaching people, is called publicity. And so if it's that could be looking at whether publicity is warranted in a particular situation. The second thing is private information. Is it publicly known or available? Is the information something that people could normally get? And a couple things to remember is that the public records are not private. And so if you say something that's in a public record, you you're not protected. It's not considered private. In Peoria, when I first got here a number of years ago, somebody said, there's a site in Peoria that is, we're talking about legal aspects of things, and they said there's a site in Peoria, and if somebody is arrested for soliciting, they put their mugshot on the police, on this police website. And so this is one of the few places that does that. And I'm not going to say whether it's right or wrong, but the reason they are able to do that legally is because it's a public record. And so anytime there's a public record, that is something that is legal to publicize. Public records are in fact private, or public records are not private. So another factor to this is whether you are a private person. And so if you decide to run for office and people look into your life, and then you will be, they are allowed to do that because you're not a private person. If you are a politician and somebody published information that you had been convicted of a felony, then that's public record. And also a politician, other things could be fair game as well. Now, sometimes we can argue that the media is too invasive in that area, but as far as legality, generally that is, if you're thrusting yourself in the spotlight as a spokesperson or in another way, that you are fair game for publicity on that. So in other words, you can't say, I'm going to be a public person, but you're only allowed to print what I want you to print, or you're only allowed to put on the internet what I want you to put on the internet. You're either a private person or you're not in the eyes of the law. Also embarrassing doesn't mean private. Somebody might say something embarrassing happens. Somebody might say, I don't want that printed, but that doesn't mean that it is actually private. When I was a news reporter, a lady called me. I had just done a story about a lady who had murdered somebody, and they claimed it was an accident. This individual moved away to another state and told somebody, oh yeah, I killed somebody in that other state. And so they called the police, the person was arrested, and they were brought back to the original city. So I aired a story, wrote the story, I aired it, and as soon as I was off the air, the phone rang, and it was the lady in the story. And she said, you can't broadcast that. And I said, well, why can't I broadcast? She goes, well, I don't want you to. And I said, well, it's a public record, so we can, but I would like to get your side of it. Why don't we talk? And we really want it to be fair, so I'd like to get your side so we can do it. And she said, I don't want to give my side. I don't want the story out. And So we continued, obviously, to do that, to use that story, and it was really a pretty sound case. She had, I would guess, she had definitely done what she had said she had done. So another aspect we looked at, publication private information. Another aspect is offensive to a reasonable person. Now think about that for a minute. Offensive to a reasonable person. How do you define a reasonable person? That makes it very difficult to do, because what I might think is reasonable, imagine if what we in Washington, Illinois think is reasonable compared to what somebody in Manhattan, New York City might think. There might be differences in how we look at things, and or even in Chicago or Los Angeles, different places may do things quite differently, and the law allows for that. And so that's one reason this is so unsettled, is because even something that happened 10 years ago, the reasonable person 10 years ago might think differently about things than they do now, or than the people now do. So that throws some. There's a little bit of insecurity, a little bit of unstableness in regard to that. For it to happen, for it to be a outrage, offensive rather to a reasonable person, it must outrage a community's sense of decency. That also is vague and is subjective from one place to another. It must also be morbidly sensational rather than informational. So if something is, might even in some cases be offensive, if it's informational and needs to help people, that could be a defense in some cases. For instance, photographs, what you are allowed to show as far as gore and gruesomeness. There have always been laws about that. Before, people didn't want to see a lot of gore. You just did not see it, even though the rules would have allowed for more. But now, even if you watch some things like Tiger King, you see some things that are a little more gore than you might normally see. Probably that's within the range of what the community would say is beyond. It's not within the outrageous capacity. So the fourth thing you would look at is whether it's a matter of legitimate public concern. Is this something that is legitimately affecting the public? And privacy torts against the media are usually fail because of a factor of newsworthiness. If something is newsworthy, if you're trying to get the information to people, there is wide latitude in the courts to allow news organizations to do that. Is it newsworthy? Was it there to tell people about an important situation? And if it was, if there's newsworthiness to it, that is going to be a factor that's strongly in favor for the media. They usually win those cases. So sometimes privacy, in the eyes of the court, privacy has to yield to the public interest, the public's right to know. Okay, so those are the four things. Let's take a look, though, at an example of the Hilda Bridges case. Very interesting case involving a newspaper and a woman named Hilda Bridges. Here's the situation. A woman is held hostage, Hilda Bridges was, held hostage in a hostage situation. The police surround the area, and she has no clothes on, and sees a hostage taker. Did that so she wouldn't leave, but she is desperate to leave because she thinks she might be shot, so she runs, flees the building without clothes. Now, there are news media there, and one cameraman takes a picture of this. It's put on the front page of the paper. So, Hilda Bridges is involved in this, and she claims invasion of privacy. However, the court said that it was part of a news story. And because it was part of a news story, it was valid, and she could not claim invasion of privacy, and that she didn't have that right. Now, the picture they had of her was not, in fact, in my notes I have part of the picture there. The whole picture is not completely revealing, I would say, and certainly I just gave you a little sliver of the black and white that isn't at all revealing. But still, she felt that she was in a situation that should have been publicized, and even though that's decided, some people will say, well, she should have that right to privacy, even though she was in that situation. Others said, we want to bring attention to this problem. And so that's a debate. Once again, it's unsettled law. They would use that case to refer to, but things are still being worked out as to how this is processed. And that was a while back. So even though that's a precedent, it still is a similar case might work out a little bit differently now. Okay, we're talking about 4 privacy torts. We talked about the first one, which is publication of embarrassing private facts. The second one is physical and technological intrusion. And wow, we are moving along. I just checked the time. So we are going to look at the second tort, physical and technological intrusion, right after this in video number 3.